Judgment in the matter of Routier and another versus Commissioners for Her Majesty's Revenue and Customs.
Lord Lloyd-Jones will explain the decision of the court.
This appeal concerns relief from inheritance tax in respect of gifts to charities where there are assets in the United Kingdom and the charitable trust is governed by the law of Jersey. Mrs Beryl Coulter died in Jersey on the 9th of October 2007. She left her residuary estate on trust for charitable purposes. The will specified that the trust was to be governed by the law of Jersey. The estate included substantial assets in the United Kingdom. The executors, who are the appellants in this appeal, were domiciled in Jersey. On the 1st of October 2010, the appellants retired as trustees, but not as executors, and were replaced by a UK resident trustee. On the 12th of October 2010, the will was amended to make the proper law of the trust the law of England and Wales. In 2014, the trust was registered as a charity under English law. In 2013, Her Majesty's Revenue and Customs determined that Mrs Coulter's gift to the Coulter Trust did not qualify for the relief from inheritance tax in respect of gifts to charities provided by Section 23 of the Inheritance Tax Act 1984. It considered that Section 23 limited relief to trusts governed by the law of a part of the United Kingdom. As the Coulter Trust was governed by Jersey law at the date of Mrs Coulter's death, and as Jersey is not part of the United Kingdom for the purposes of Section 23, it considered that the relief was not available. The appellants appealed against the Revenue's determination on the basis that it is incompatible with Article 56 of the Treaty establishing the European Community, which is now Article 63 of the Treaty on the Functioning of the European Union, which prohibits restrictions on the free movement of capital between EU member states and between member states and third countries. The Revenue and Customs, on the other hand, argued that Article 56 does not apply here because although Jersey does not form part of the United Kingdom for the purposes of Section 23, a movement of capital between the United Kingdom and Jersey should be regarded as an internal transaction taking place within a single member state. As a result, it maintained, EU law on free movement of capital had no application to this situation. The Court of Appeal accepted the appellant's submission that Jersey is to be regarded as a third country for the purposes of Article 56, and that accordingly EU law on free movement of capital applied, but decided that the restriction of Section 23 to trusts governed by the law of part of the United Kingdom was nevertheless justifiable under EU law. The Supreme Court now unanimously allows the further appeal. Lord Reid and Lord Lloyd-Jones give the judgment, with whom all members of the court agree. The first question which arises on this appeal is whether a movement of capital between the United Kingdom and Jersey should be regarded as an internal transaction taking place within a single member state for the purposes of Article 56. Article 56 prohibits all restrictions on payments or the movement of capital between member states and between member states and third countries. It is common ground between the parties that Article 56 applies to gifts to charities and that Jersey is not a member state. The issue therefore turns on whether Jersey is to be regarded as a third country. The bailiwick of Jersey is a crown dependency which, in common with the other Channel Islands, enjoys a unique relationship with the United Kingdom through the Crown. It is not an independent state in international law. The United Kingdom government is responsible for its international relations and has the power to extend to Jersey the operation of a treaty concluded by the United Kingdom. Article 299 of the treaty creating the European Community, which is now Article 355 of the Treaty on the Functioning of the European Union, makes express provision in respect of the Channel Islands. The combined effect of Article 299 and Protocol 3 to the Act of Accession of 1972 is that those rules of EU law relating to the common customs area, including the free movement of goods, apply in Jersey, but that, save to the extent stated in Protocol 3, other rules of EU law do not apply in Jersey. In particular, EU rules on free movement of capital do not apply in Jersey. In its judgment, the Supreme Court considers that decisions of the Court of Justice of the European Union provide a systematic and consistent approach to this issue. The question is whether a territory is to be regarded as a third country. That question is context-specific and will depend on whether, under the relevant treaty of accession and supplementary measures, the relevant provisions of EU law apply to that territory. As EU rules on free movement of capital do not apply to Jersey, Jersey is to be considered a third country for the purpose of a transfer of capital from the United Kingdom. Accordingly, EU rules on the free movement of capital do apply to transfers of capital between the United Kingdom and Jersey, and it is accepted that the refusal of relief under Section 23 is a restriction on that free movement. The second question which then arises is, given that EU law on free movement of capital applies, whether the refusal of relief under Section 23 in respect of the gift to the Coulter Trust is justifiable under EU law. On its face, Section 23 does not impose any restriction on the free movement of capital and is therefore compliant with Article 56. The only restriction is that imposed by the judicial gloss placed on the words now found in Section 989 of the Income Tax Act 2007 by the House of Lords in Camille and Henry Dreyfus Foundation, Incorporated, and the Inland Revenue Commissioners, 1956 Appeal Cases 39, a restriction which, when incorporated into Section 23, had the effect of confining relief under that provision to trusts governed by the law of a part of the United Kingdom and subject to the jurisdiction of the United Kingdom. There can be no doubt that the Dreyfus gloss on Section 989 is incompatible with Article 56. It is plain that the restriction of relief from inheritance tax to trusts governed by the law of part of the United Kingdom cannot be justified under EU law. Article 56 is directly applicable and must be given effect in priority to inconsistent national law, whether judicial or legislative in origin. The Dreyfus gloss on Section 989 cannot be applied to Section 23 in situations falling within the scope of Article 56. Since it is undisputed that the Coulter Trust satisfied the conditions appearing on the face of the provision at the relevant time, it follows that it qualifies for the relief. Accordingly, the appeal is allowed.